Hello, I'm Mark Thompson, Managing Partner of the Riverside office of Atkinson, Andelson, Loya, Root, and Romo, and I'm here in conjunction with the Inland Personnel Council and the San Bernardino County Superintendent of Schools to present you with a brief overview of the Brown Act and a few topics in boardsmanship. Now, we've geared this to be a primer for new board members, but also a refresher for existing board members. And with that, let's jump right into the big question: what is the Brown Act? The Brown Act is California's open government law, and we know from the government code that the law requires that public agencies exist to conduct the people's business. Therefore, the intent of the law is that government agencies' actions shall be taken openly, and their deliberations are to be conducted openly in front of the public. The Brown Act also tells us that all meetings of a legislative body shall be open to the public, and all persons shall be permitted to attend and participate. So who does the Brown Act apply to? Obviously, most of our clients are boards of education, but it applies to all local government officials. Interestingly, it also applies to board members-elect. So any of you that are fortunate enough to have been on the positive side of the recent election, as soon as you're certified, the Brown Act applies to you. Now, in addition to the Board of Education, the Brown Act also applies to standing committees of the board, and also ad hoc committees appointed by the board that is comprised of both board members and other people. It excludes ad hoc committees of the board that are comprised only of less than a quorum of board members. So if you have a subcommittee of just 2 out of your 5 board members, it is not subject to the rules of the Brown Act. It also excludes committees that are appointed solely by the superintendent and not appointed by the Board of Education. So we talked about a meeting. What's a meeting? And it seems simple, but it's not. As you might imagine, the Brown Act goes to great length to describe exactly what a meeting is and what a meeting isn't. A meeting is any congregation of a majority of the members of a legislative body, no matter how informal and no matter what means they use, including electronic, if they're going to hear or discuss or deliberate or take any action on an item that's within the subject matter jurisdiction of the agency. Now, these rules, as they are the open government rules, you can imagine that they're required to be construed as broadly as possible. So that means that in a 5-member board, no more than 2 members, or in a 7-member board, no more than 3 members, may communicate with each other on any single subject within the jurisdiction of the body outside of a duly noticed and agendized board meeting. In addition, it's very important that agencies avoid any kind of serial meeting. Now, you'll get some more training on what a serial meeting is, but in general, anytime you put 3 board members' heads, 3 out of 5 together, on a single subject, you run the risk of creating a serial board meeting. So if the first board member talks to the second board member about a subject, and then that member talks to a third member about a subject, you've now put 3 heads together, and in a 5-member board, that constitutes a serial meeting and could be a violation of the Brown Act. That also includes communicating through an intermediary. So in the case of a K-12 school district, if 3 separate members all talk to the superintendent about the same subject, the superintendent now has put 3 heads together, and we have a potential serial meeting, potential Brown Act violation. Now, the Brown Act has been changed recently to actually encourage board members to communicate with their constituents via social media. What that means is that a board member may solicit and receive feedback from his or her constituents via social media, and that doesn't constitute a violation of the Brown Act. However, board members must avoid comments and likes, any kind of communications back and forth to other board members through social media, because even one of those communications could constitute a violation of the Brown Act. One-way communications are permitted, but you do need to use caution because you don't know who that person is going to communicate to next, and that could result in a potential Brown Act problem. But a good example of a one-way communication is the Friday memo that you might receive from the superintendent of your school district. As long as that's a one-way communication, there's no risk of that turning into a Brown Act violation. It's only when the feedback occurs that you have potential risk. So once you get into a meeting, what's important? There are a few important components of a board meeting. And I suppose the first one goes straight to the heart of the matter, which is public participation. Any government agency meeting must include an opportunity for the public to comment back to the legislative body. We call it public comment. Now, public comment is not without its rules and regulations. It is appropriate and, in fact, explicitly allowed under the law for a board or an agency to impose reasonable regulations on public comment. And if you look at your board bylaw, you'll find that most likely you have the typical regulation, which is 3 minutes per speaker, up to a maximum of 20 minutes per topic. Check your own board bylaw because that does vary from district to the district. Now, public comment must occur on closed session items, must be allowed on closed session agenda items prior to closed session. Separate from that, there must be an opportunity for the public to comment on open session agenda items prior to those matters coming up on the agenda. And even in the case of a regular meeting, non-agenda items that are within the subject matter jurisdiction of the board. In a special meeting, however, public comment is only on agenda items. Another interesting thing about board members that's come up recently as a result of the pandemic is the question of remote meetings. Now, there are traditional rules in the Brown Act governing teleconferencing that would allow a board member to teleconference in to a board meeting following what we call the traditional rules. And what that means is the teleconference location, address, must be listed on the agenda for the meeting. And the agenda must be posted at that teleconference location. And that location must be held open to the public and allow for public comment. Another issue that's come up more recently is the question of disruptions during board meetings. Now, the Brown Act has traditionally had language that talked about what to do in case of a disruption, but there's actually new legislation coming into play that makes it more explicit. And if you look at your board bylaws, you'll see your bylaws cover disruptions. It's covered now in the Brown Act, and it's also covered in both the Education Code and the Penal Code. You must give a warning, and then if the person remains disruptive, they can be removed. As an alternative, the board, if necessary, may clear the entire room, with the exception of any members of the media who are not taking part in the disruption. Or the board can retreat into closed session to see if the disruption goes away. Finally, the board has the option to adjourn a meeting and reconvene at a later time if there's no other way to quell the disruption. Now, board meeting agendas have a lot of specific requirements, but the first one is you must have an agenda and it must be posted in advance of the meeting, including on the district's website if it has one. The agenda must be posted at least 72 hours in advance of every regular meeting and 24 hours in advance of special meetings. There's also a rare case of an emergency meeting that would allow for an agenda to be posted 1 hour in advance, but these are reserved for true emergencies like a work stoppage or a crippling disaster. The items on your agenda must reasonably apprise the public of the business that's going to be transacted by the agency, so the public can determine whether or not they are interested in coming to the meeting and participating. Any agenda materials provided to the board in advance of the meeting become public records right away, unless they're otherwise protected by law. We know that the law requires that all meetings of a government agency must occur before the public, but it does allow for privacy for closed session items in specific situations. The reason for that is that confidentiality on certain matters actually is a benefit to the public. Some of the typical closed session items involve personnel matters. The benefit to the public is that if you're talking about evaluations or disciplinary matters, the public benefits from the privacy interest in employment records. There's also conferences with legal counsel on existing or anticipated litigation. Liability claims can also be addressed in closed session, conferences over real property negotiations, and again, you wouldn't want the adverse party in a property negotiation to hear the board talking about their price point because that will cost the public money. Similarly with labor negotiations. After a closed session, the board must reconvene in open session and report out any actions that were taken in closed. It's also important to remember that all closed session discussions are confidential according to the government code and cannot be disclosed without the authority of the board majority. Under civil law, enforcement can come in the form of civil injunctions or writs of mandate. And in the worst cases, these can result in nullification of whatever action the board took that was in violation of the Brown Act. This could include cancellation of contracts even after work has been performed or goods have been exchanged, and it could cancel settlement agreements in negotiations or in litigation, and these can be pretty drastic results. There's an alternative procedure under the civil prong, and that is the cure and correct process that appears in the Brown Act at Government Code 54960.1. On the criminal side, there are criminal ramifications to intentional knowing violations of the Brown Act. These are misdemeanors that can be prosecuted under the law. There is a safety net, though, because good faith reliance on an opinion from your legal counsel could preclude a finding that there was an intentional violation. Now let's switch gears and talk for a couple of minutes about boardsmanship. I think the first most important thing to remember is that individual members of the board have all the rights and powers of any members of the public, with one exception, and that would be that they have to comply with the Brown Act. However, you don't have an unfettered right to give direction to district employees. In fact, no board member has any individual authority unless it's appointed by a majority of the board to take certain action. But individuals can't direct staff. Individuals don't have the power to make requests of staff. And in fact, the typical board bylaw requires that board members submit information requests to the superintendent so that staff can be appropriately charged with gathering that information and providing the appropriate response. Similarly, your board bylaw will most likely say that individual board members are not empowered to investigate complaints. Now, your board president typically has several additional powers, and the first is that he or she is the official spokesperson for the board. The board president also is charged with the responsibility of setting the board agenda, usually in combination working with the superintendent, and also to preside over the meetings. And our final slide is an important topic of boardsmanship, and that is the conflict of interest laws. Now, they're codified in your board bylaws, and it tells you what a conflict of interest is and what must be avoided, and perhaps most importantly, tells you how and when to file your Form 700, which is your Declaration of Economic Interest. So, conflict of interest law comes from three different places generally, and the first is Government Code 1090, and it says that there shall be no financial interest by an individual board member in any contract entered by the board. It also comes from the Political Reform Act, and in those cases, in some cases, action by the board is prohibited. In other cases, a board member with a conflict or a remote interest must disclose and recuse from any vote of the board where a remote interest exists. And then finally, under common law, there's the simple principle that members of a legislative body must avoid the appearance of impropriety whenever possible. There are some exceptions related to collective bargaining, or where a board member's spouse has prior employment with the agency, and we'll save those for another day. But again, the Form 700 requirement is very important for our new board members because you're going to have to file one right away. It's a declaration of all your economic interests that might be relevant to any decision that you make as a part of your local agency or your school district. You're required to file these reports upon entry to your position, upon exit, and then each year in between. One part of the Form 700 reporting requirement mandates that you disclose any gifts that you received under certain limits established in California law. I think I've run out of time, and so I'm going to thank you for your attention and encourage you to look deeper into these issues. They are complex, and they do take a lot of time to get used to, and you'll have lots of time to do so in your new position or your continuing position. Thank you very much.